Welcome, everyone. Thank you so much for joining us. We're going to give it a minute for everybody to fill in from the waiting room. Really excited to be hosting this event today and really appreciative for so many of you taking your lunchtime to learn with us about AB 1633. Very appreciative of our co-sponsors for this event, who also were our co-sponsors on passing AB 1633. Hack, Back, and Spur, the Housing Action Coalition, the Bay Area Council, and the San Francisco Bay Area Planning and Urban Research Association. Also very excited to have the bill author, Assembly Member Phil Ting, joining us in just a minute, working through some technical challenges. And very excited to have Professor Chris Elmendorf, one of California's leading public intellectuals on housing law and policy. And yeah, this bill was really a very exciting opportunity to address some of the abuses we've seen around the California Environmental Quality Act and make it work better for housing. So really excited to be able to share more information about it with you. And yeah, I'll give it just another minute for the Assembly member. A couple other housekeeping notes I'll point out. This is a webinar. There is a Q&A feature. So if in the course of the presentation you have questions, details you'd like more information on, please feel free, please put your questions in the Q&A. We'll be monitoring those so that you can, so we can get answers to you. And I don't think I introduced myself. My name is Aaron Eckhouse. I'm the Local and Regional Policy Program Director at California YIMBY. All right. Got a lot of people in here today. Very excited to see it. Thank you all for being here. See some names that I recognize. Always love that. I'll see some names that I don't recognize, which is also always fun. So yeah, if you give us just a minute, we're hoping to have Assembly Member Ting join us. Yeah, we're also going to be recording this event just so everybody knows. And so we'll make that information as well as Chris's slides available after the event. Appreciate everyone's patience here. We're having some unexpected Zoom challenges. We'll be ready in just a minute. And I know a lot of great information to come in Chris's presentation. Chris, maybe you want to start us with some background information on AB 1633.
Well, as Corey quipped, just like AB 1633, we need to try more than once with the technical aspects here. But AB 1633 was a bill that actually got started 2 years ago. It grew out of a controversy in San Francisco around the 469 Stevenson Street project, which brought to light a conflict between CEQA and the Housing Accountability Act that hadn't been widely appreciated before then. And the first year the bill, under a different name, made it all the way through both houses of the legislature, all the policy committees, until it died without a vote in the Appropriations Committee in the second house. One of the peculiarities of California legislative procedure is that the chair of the Appropriations Committee apparently can kill any bill he wishes to kill. But it came back again the next year as 1633, and through a rather miraculous journey aided by all of the co-sponsors of this presentation, was enacted with no votes to spare, and then signed into law by the governor. But I'll save the content of my talk until after we're able to hear from the bill's author, Assemblymember Ting.
Aaron, you're muted.
Thank you so much to Assemblymember Phil Ting for joining us, for your leadership on authoring AB 1633. Take it away.
Thanks, Aaron. Really appreciate California YIMBY, the HAC, Bay Area Council, Spur, as well as a lot of other partners. And really thanks to my good friend Chris Elmendorf for helping architect the bill. It's been a 2-year struggle to really just present and get some teeth into the Housing Accountability Act. This act is nothing new. It's been around for decades. And literally, like many of our bills, it's been used to, it's been cut up into Swiss cheese, so it's really been easy to circumvent. We saw that with the Surplus Lands Act. I work with a number of people to tighten up our Surplus Lands Act so we can get affordable housing built. This is just another struggle to, again, tighten up the original intent of the law. And simply, the law was created to provide a check against local governments so that they couldn't just arbitrarily stop housing. We saw what happened here with that lot on Stevenson in San Francisco. And really what we want to make sure is that this doesn't happen statewide overall. It took a coalition, a significant amount of work. Our major opposition was the building trades. Unfortunately, they were never able to really get us amendments that we could accept or really work with. We did try to have a lot of dialogue with them, and unfortunately, we're never able to get them on board. But we did make some great amendments to the bill, I think, to make it better, to sort of tighten it. But it was definitely a struggle. I think this just points out the reason we need to continue to have this fight at the state level. We're seeing just local governments not moving fast enough to entitle land, to really move the goalposts on building more housing. And so I could really see a movement toward just more and more of the state taking away local control, because we know we have these 2 million homes to get built. They're not getting built fast enough. And I could just see, unfortunately, the state taking greater reins over this housing struggle, just because local governments aren't getting the job done. Again, really, we just want to thank all the groups who are on today for their tireless advocacy. I think we know that if we can't build more housing in San Francisco, well, not just San Francisco, but really in California, it's going to create a huge problem for our economic growth and really for our economic prosperity down the road. So with that, let me just stop there and just thank again all the groups who are sponsors, supporters, fighters, for helping us out, and really again thank Chris for all of his leadership and really his great idea to tighten this language up. Thanks a lot.
Thank you so much, Assemblymember. Thank you for joining us. Thank you again for your leadership on this bill. And I'm going to turn it over to Chris, who's going to take us in detail through exactly how this bill is going to make a really important difference for getting housing built across California. Thanks, Chris.
Thank you. I'd like to as well thank Aaron and the sponsors of the bill for inviting this presentation, and above all, Member Ting, who was really tireless in his work on this bill, and his staffer, Linda Rios, who led the work on this bill, who was nothing short of fantastic. I contributed a few ideas along the way, but it was really their work that got the bill done. So with my talk today, I want to start by laying out the problem that 1633 was meant to solve. Then second, the way that 1633 tries to solve that problem. Third, I'll talk a little bit about the 1633 bonus, which is a really interesting and I think productive provision added at the suggestion of local government advocates. And finally, I'll close with some thoughts on what 1633 I think will mean and should mean for the development of new CEQA exemptions going forward. So let's start with the problem. We have a law called the Housing Accountability Act that's been on the books in California since 1982, strengthened in various ways over the years. And the gist of the Housing Accountability Act is that if a project complies with the applicable standards, a city can't deny the project or reduce its density unless the project would cause a serious health or safety problem. Pretty commonsensical idea, but the Housing Accountability Act says it doesn't exempt a project from CEQA, and CEQA, as interpreted by the courts, allows cities to delay without any limitation the very same projects that the Housing Accountability Act says the city can't deny. And from the point of view of a developer, infinite delay or indefinite delay while you're making interest payments to the bank is the same thing as a denial, which is the thing that the HAA says the city is not supposed to do. So this problem really came to light in the context of the 469 Stevenson Street project in San Francisco, where the city did a full environmental impact report for a infill project on a parking lot downtown in a priority development area under the regional climate plan, as good as an environmentally as good a project as could ever be hoped for. And yet the project was controversial because the developer refused to play along with a local advocate's demand that the developer donate a third of the site to the city. And the Board of Supervisors, not being able to deny the project under the HAA, instead came up with make-work demands for additional environmental studies of things that aren't even environmental impacts within the meaning of CEQA. Then a year later, the same thing happens in the context, or essentially the same thing happens in the context of a project that was exempt from CEQA, should have been treated as exempt from CEQA, was treated as exempt from CEQA by the planning department. But Supervisor Peskin decided he didn't want the project. And so he said, we're not going to approve this CEQA exemption once it was appealed to the Board of Supervisors. So there are time limits in CEQA for the completion of environmental review, but there is not in CEQA a remedy for a city's violation of those time limits. That's the fundamental problem. A city can sit for years on a completed environmental impact report. And if it does, what can a court do? Well, according to the cases, a court can order the city to take some action on that completed environmental study, either to certify it, meaning to finish the process, or to decide not to certify it and order further study. But, and here's the problem, if the city says that further study is ongoing, the courts won't do anything to address CEQA compliance until the city says, okay, we're done with all the studies we want to do. So long as the city asks for further study, even if something that isn't even an environmental impact under CEQA, it can delay the project forever. This principle was first enunciated, or maybe tacitly made clear, in the Schellinger case from 2009, and then it was relied upon by the San Francisco Superior Court in denying a claim that was brought by YIMBY law challenging the city's icing of the Stevenson Street project. And even after the fact, like if the city finally, after 10 years or 20 years or 3 years or however long, decides it's willing to wrap up the CEQA process, there's no penalty for a city. There's no fines, there's no fee shifting, there's no nothing that would discourage a city from using bad faith CEQA delays to stall a project that it's not allowed to deny. Okay, that's the problem. So the 1633 solution is to declare the abuse of CEQA to be itself a violation of the Housing Accountability Act. That's big picture. Now we'll get into some more of the details, how this works in practice. So the crux of 1633 is to say, let's, through the HAA, enforce the time limits that exist in CEQA for the completion of environmental review. So 1633 takes the substance of CEQA as given. It doesn't create any new exemptions. It doesn't change the standard for what's a legally sufficient environmental impact report or negative declaration or exemption finding. The substance of CEQA stays the same. 1633 also, for the most part, takes CEQA's time limits as given, but with a few revisions and clarifications. So there's actually no express time limit in CEQA for cities to determine whether a project is exempt or not. I've argued that there's kind of like an implied 30-day limit. HCD has relied on that argument in some of its housing enforcement work. But 1633 says, okay, we're not going to worry about what might be implied by other parts of CEQA. We're going to make clear that for exemptions, at least, there's a 60-day time period, right? So city has 60 days from the time it receives the completed project application to decide whether the project is exempt. If the project is not exempt, the city has 180 days to prepare a negative declaration. If that's the route it goes, or 1 year for an environmental impact report. Those are the existing time limits in CEQA. So the mechanism works as follows. The principal mechanism works as follows. After the applicable CEQA time limit has passed, so 60 days if the developer thinks the project is exempt, or 180 days if it's a developer thinks the project is eligible for a negative declaration. The project applicant, not third parties, no YIMBY groups, no NIMBY groups, just the project applicant may call the question of whether the project is exempt under CEQA, exempt from further environmental review, or whether a legally sufficient environmental review has been conducted. That is, a proper negative declaration or a proper environmental impact report with the principal forms of environmental review. Okay, so once the applicant calls the question, the city then has a period of time to make up its mind, and how that works depends a little bit on whether the applicant thinks the project is exempt or not. So I want to walk you through the process. First, if the applicant thinks the project qualifies for an exemption, such as the Class 32 exemption for infill projects, which is a principal exemption that's used for many projects in places like San Francisco, or there's a common sense exemption, or there's special exemptions for transit priority projects. There's a whole host of exemptions that might apply to a project. So if the applicant thinks the project is exempt, here's what they do. They prepare everything that a city would normally include in what CEQA calls a notice of exemption, which is the public notice a city gives after it makes a final exemption determination. The applicant prepares all the information, gives it to the city, along with the excerpts from the record, that is, any material that was submitted previously with a project application or that has been gathered up as part of a building of the record of evidence to clarify that the project is exempt. The applicant prepares all of this and gives it to the city. The city then gives public notice that the applicant called the question of whether the project is exempt. From the date of the applicant's calling of the question, the city has 90 days, which you can then extend if it needs to 180 days, to make a final decision on whether the project is exempt or not. If the city fails to decide within that 90 to 180 day period, or if it fails to issue the exemption, if there's substantial evidence in the record that would allow a reasonable person to find that the project is exempt, that violates the Housing Accountability Act. Okay, this is a really key idea. Substantial evidence in the record that would allow a reasonable person to find the project is exempt. What does that mean? It means essentially that if there is a reasonable argument in light of the evidence the applicant has gathered that the project is exempt, then as a matter of law, the project is exempt. Or put another way, if the record is such that the city could determine the project is exempt and have that determination upheld in court, then the project is exempt. In other words, exemptions are mandatory, right? If the city can issue the exemption for the project under CEQA, the city must issue the exemption for the project under CEQA. Okay, so I'm going to give a little alert to city attorneys and then a practice tip for applicants in the next slides. So here's the alert. Check your municipal code about exemptions and internal appeals. It may need updating for you to comply with the time limits under 1633 and avoid an HAA violation. Why is this? CEQA designates that the elected city council or county commission of a local government is that government's official CEQA decision maker. That means that any determination that's made by staff has to be appealable to the city council, the county commission. Under background legal principles, this is not anything in this statute, right? This is just basic understandings of how administrative law works. An agency decision that includes a decision of a city or county is not final. It's not final if it is subject to internal appeal. So 1633 requires a final decision within 90 to maybe 180 days of the applicant calling the question. And that means that it's not enough, given this the structure of CEQA where the city council is the final decision maker. It's not enough for staff to say, oh yeah, your project is exempt. Rather, the city has to be able to get that CEQA determination before the city council within that 90 to 100 day time period. So to see how this works, it's going to be a problem in practice or in some places, look at San Francisco. Under San Francisco's administrative code, this is adopted by the Board of Supervisors, public notice of a CEQA exemption is provided only upon approval of the project. The exemption is then appealable to the Board of Supervisors within 30 days from the date of the approval action. That means there is no way in San Francisco to get the final CEQA determination made on an exemption until the project is approved. So either the city has to start approving projects really fast, right? Once an applicant calls the question, or else it has to change its internal appeal process under CEQA. So to comply with 1633, San Francisco is going to have to do one of three things, which is going to require action by the Board of Supervisors to amend the city's administrative code. One, well, I guess this could be done by planning, but the odds of the city being able to accelerate the approval process so that once an applicant calls the question, the project can be approved and the CEQA appeal resolved within 90 to 180 days. I mean, that would be a miraculous transformation in a city that now takes 3 years typically to process any project application. But if the city can do that, great. More realistically, I think the Board of Supervisors will probably have to or should consider enacting a pre-project approval process for giving public notice and internal appeal of CEQA exemptions for 1633 projects, or simply when an applicant calls the question, make the supervisors the frontline decision maker on the exemption so that there is no appeal process, because the calling of the question means that, or once the question is called, staff will prepare a report as to why staff thinks the project is or isn't exempt. That report will go to the Board of Supervisors, and then the Board of Supervisors within that 90 to 180 day period will vote on whether to approve the exemption or not. And again, if they deny the exemption in cases where the exemption could be issued and upheld in court, that's an HAA violation, which I think the city will likely want to avoid. Okay, practice tip now for project applicants. When you give that calling of the question and you prepare those materials for the city to include in its public notice, you should include what's called a Mahan notice. Now, if you ask a typical land use attorney what a Mahan notice is, they will say, I have no clue what you're talking about, even a veteran California land use attorney. So what is it and why does nobody know what it is? Well, there's this old law, dates from the 1970s, called the Permit Streamlining Act. And the Permit Streamlining Act says a project becomes deemed approved by operation of law. That is automatically approved if the city fails to approve or deny it within a short period following the conclusion of the city's CEQA process. That period is 60 days for projects that are exempt from CEQA. The Court of Appeal has said that this automatic approval or deemed approval provision only operates if the applicant or the city gave public notice that the project could be deemed approved, could be automatically approved by operation of law. That's from the Mahan case. But even though there's this precedent from 2006, this whole concept of a deemed approved permit was an afterthought because cities just wouldn't finalize their CEQA exemptions until they approved the project, right? You can see that in San Francisco's administrative code that I had in the previous slide, right? The exemption is not appealable. It's not, or the notice of the exemption isn't provided and the exemption isn't appealable until the city approves the project. So of course, if that's the case, there can't be a deemed approved project in San Francisco. But that's the old situation, right? The new situation under 1633 is that the city has to make the CEQA exemption, the final CEQA exemption decision within that 90 to 180 day period after the applicant called the question. And once that final CEQA exemption determination is made, that 60-day period for approval under the Permit Streamlining Act starts to tick. That clock starts to tick. And if the city doesn't then act within that 60-day period, the project is going to be approved by operation of law if the public was given notice of the possibility of automatic approval. So it's a very easy thing for, or will be a very easy thing for project applicants to include that Mahan notice in the package of materials they give to the city, which is then publicly posted. And there are still some questions under the Permit Streamlining Act about the Mahan notice and whether there's some due process issues, and those will have to get litigated. But the crux of it is that the Permit Streamlining Act, which was a law that basically didn't accomplish anything for many years, is suddenly going to be very relevant in cases where projects are CEQA exempt. Okay, so let's think now about the situation where the applicant concedes that the project is not exempt. So in order to get the CEQA clearance, you have to either prepare a negative declaration explaining why the project won't have a significant environmental impact, or you have to do a study of potential significant impacts, which is the environmental impact report. So if we're in this non-exempt category, the applicant can call the question under 1633 only after the city has held a public hearing at which the draft negative declaration or environmental impact report, whichever it is on the agenda and could have been adopted, right? So if you think about the Stevenson case, that was a case where the project went through an environmental impact report. The applicant could have called the question after the meeting of the Board of Supervisors, in which the Board of Supervisors had that environmental impact report on its agenda and could have adopted it or certified it. The city then, the applicant calls the question, has 90 to 180 days or 90 days extendable to 180 to make up its mind. And again, the HAA is violated, or if the city fails to act within that time period, or if the city, instead of approving the environmental impact report or the negative declaration, requires further environmental study. If, when we're talking about a negative declaration, there's no fair argument about a potentially significant environmental effect, or if we're talking about an environmental impact report, the city can't point to substantial evidence in the record that additional environmental study is legally required. And without going into further depth right now, these legal standards give the benefit of the doubt to cities in close cases, in contrast to how 1633 treats exemptions, where issuance of the exemption is mandatory if the exemption could be issued. Okay. I want to say a word about statutes of limitations. While a city is procrastinating, that is taking more time than CEQA nominally allows, the applicant can take as long as it wants as well to call the question. Doesn't have to call the question ever. It can let the city take 5 years if it wants to let the city take 5 years to do an environmental impact report. But if the city makes an official decision to deny an exemption or to order further study rather than approving a negative declaration or certifying an EIR, if the city does that official decision and gives notice of it to the applicant, then the applicant has 35 days either to accept the city's decision or to give notice that it thinks the city messed up, that the city ordered further study where it had to approve a CEQA document. And if the applicant fails to call the question within the 35 days, it's out of luck. Okay, there are some really important substantive limitations on the types of projects that are eligible for this 1633 process. Some of those are about geography and the type of housing. So the project must consist of dense housing, a minimum of 15 dwelling units per acre, which is roughly townhome style densities. And it must be in an urbanized area as defined by the Public Resources Code. And that is basically cities and contiguous suburbs with at least 100,000 people. And the project must qualify for the HAA protections. So whatever the applicable general plan and zoning standards are that apply to the project complies with those. There are also environmental criteria. The site must not be environmentally sensitive as defined in SB 35-423. That's the bill that requires ministerial, that is automatic or non-discretionary approval of certain projects. The site can't be in a high or very high fire severity zone. And the site must satisfy one of several what I call green criteria, either bordered on 3 sides by urban uses in a very low VMT, vehicle mile traveled location, within a half-mile walk to a transit corridor, or close to 6 or more amenities as defined. So it has to satisfy one of these infillish criteria. Okay. Finally, remedies. Let's say the city fails to make up its mind about the CEQA issue within the allowable time period, or the city denies an exemption that the project was eligible for. That's an HAA violation. Well, you might say, so what? What happens then? The plaintiff who says there's been an HAA violation because the city messed up the CEQA process for a 1633 project, they can get all of the normal HAA remedies except for fee shifting. Normally, you can get attorney's fees from the HAA anytime you win. 1633 says the plaintiff can only get attorney's fees if a court finds the city acted in bad faith. So the city denied an exemption because it had a reasonable belief that the project wasn't exempt, and the court later disagrees with the city's determination. That's a violation of the law because the city had to issue the exemption for the project, but the city wasn't in bad faith, and so the city is not going to be on the hook for paying for the plaintiff's attorney. The usual or standard HAA remedy is a court order compelling compliance within 60 days, backed by the court retaining jurisdiction and threats of fines for further non-compliance. So basically, a court can tell the city whatever it has to do to finish the CEQA process and to approve the project. If the court finds the city was in bad faith, the court can direct the city to approve the project rather than just telling the city what to do. So an order directing the city to approve the project is the more drastic remedy. Okay, so I said I was going to mention something about the 1633 bonus. What is that? Well, it's a disincentive for NIMBY litigation in cases where a city wants to approve a project. So let's say we're in a situation where there's a project the city council actually likes, but neighbors or other local groups don't like it. What happens in that situation? Well, not infrequently, the opponents will bring a CEQA claim against the project, or they'll bring an argument saying it doesn't comply with general plan or zoning. And if the opponents of the project win, even on like a procedural formality, something that's not really substantive, but there was like a failure to dot an I or cross a T or something, they often get attorney's fees under a general provision of the civil code, especially if it's a nonprofit group that brought the claim. And local governments in the negotiations over 1633 says, well, this is really putting us between a rock and a hard place, because if we approve the CEQA document, we're going to get sued by the NIMBYs. But if we deny it, it's now an HAA violation. So like, how are we supposed to live in this new world? And the solution, which I think is quite reasonable, is to say, first, that if the city reasonably denies a CEQA exemption or reasonably requires further environmental study, maybe the city messes up. But if it was in good faith, the developer who sues the city isn't going to get the city to pay for the developer's attorney's fees. And likewise, if the city approves the project and the approval was in good faith, then normally the NIMBY group that is challenging the city's approval shouldn't get attorney's fees either. And the way this works is that 1633 says that when the court does the balancing of interests that it's supposed to do under Code of Civil Procedures 102.1.5, it should give due weight to whether the local agency's decision furthers the policies of the HAA, and then critically, that if a city in good faith approves a dense infill project on a site that meets 1633's environmental criteria, an award of fees, that is attorney's fees, to the plaintiff who challenged the project's approval is, in the language of the bill, rarely, if ever, appropriate. So a court does still have discretion, if it wants to incentivize NIMBY litigation with an award of attorney's fees. But there's now a legislative finding, a legislative declaration, that when we're talking about dense infill housing on environmentally benign sites, courts should rarely, if ever, award attorney's fees to those who are attacking a project approval where the city was in good faith approving the project, right? So like if the city is like being bribed by a developer to approve a project, that's obviously not something the city is doing in good faith. If it's patently obvious that the project doesn't comply with the applicable requirements and the city approves the project, that's not in good faith either. But if the city is being reasonable, even though it made a mistake, the city doesn't have to worry about being on the hook for attorney's fees, whether it's being sued on the one hand by the developer, where the city made a decision to require further study, or on the other hand by NIMBYs, where the city made a decision to wrap up the CEQA process and approve the project. And this, to my knowledge, is the first time the legislature has put any limitation on the award of attorney's fees to YIMBY plaintiffs, and it may prove to be one of the I think most significant and lasting contributions of the bill. Okay, last comment or last thought I want to share with you before we turn to Q&A. The time has come for OPR, the Office of Planning and Research, which writes the CEQA guidelines, including so-called categorical exemptions under the CEQA guidelines. It's time for OPR to write an objective standards exemption for infill housing projects. The whole thrust of the Housing Accountability Act, and in fact, beyond the Housing Accountability Act, the whole thrust of the last half dozen years of state housing legislation is to make the rules clear about project approvals. You see that in SB 35 requirement of ministerial permitting for certain projects. You see that in AB 2011, which was the big corridors upzoning bill from 2 years ago. You see that in the ADU laws, and you see that in the Housing Accountability Act, which now, while allowing a zone of discretion, says that city can't use their discretion to deny or reduce the density of a project. What we don't have any objective standards for is CEQA. There's a general infill exemption, and then that infill exemption is riddled with exceptions for cases where a project might have cumulative impacts or might have some subjective impact on a historic resource. The CEQA infill exemption is not objective, but it's now mandatory, right? So cities are in this strange position where they have to issue exemptions for projects that are eligible for exemptions, but it's often not clear whether a project is eligible for an exemption because the standards for an exemption are, frankly, murky. This problem can be fixed and should be fixed by the Governor's Office of Planning and Research through an update to the CEQA guidelines that finally establishes a clear-cut exemption that covers most housing development in already urbanized areas. So write to the governor and say, hey guys, when is the objective standards infill exemption coming? All right, that's all I've got to say, but I am happy to turn to questions at this time. And I know we got started a little late, and if the questions go long, I'm also happy to stay on past 1 o'clock.
Wonderful. Thank you, Chris. That was really interesting. And we have a number of questions. First question comes from Marty Ackerblom. Question about the process for EIRs and negative declarations, and about what recourse there might be for a project applicant if the city is not scheduling a public hearing.
That's a great question. And honestly, I think that's a weakness of the bill, that it doesn't include an express provision to require that. But on the other hand, I don't think we're entirely out of luck in that case, or the applicant's entirely out of luck in that case, because under the old CEQA case law, what are the things that a court can order? Well, if the city is just sitting on its butt and doing nothing, a court can order the city to take some action. And I think taking some action at a minimum means calendaring the draft EIR for a hearing at which it could be adopted. So I do think that's a remedy you can get from a court, though obviously going to court in that circumstance isn't necessarily what you're going to want to do.
Thanks, Chris. Next question from Francis Schreibeg is about who has the ability to put evidence in the record for consideration on eligibility for an exemption. Is that only evidence from city staff? Is there a mechanism for either the applicant or external experts to incorporate evidence into the record?
That's a great question. So anything that the applicant includes with their project application will be evidence in the record. So the applicant is able to get information into the record that way. Likewise, any information the applicant sends to the city supplementing their application. That's evidence that becomes part of the record. And then as far as the general public goes, once the applicant calls the question, the city has to give public notice of the applicant calling the question. And the general public then has an opportunity to submit information to the city that it thinks is relevant to whether the project is exempt or not. And any information the city receives prior to the time of its decision is considered, as a matter of law, part of the administrative record.
Great. Now a couple of questions about how this might interact with specific CEQA and HAA pathways. So a question from Riley Hurd, if this can be used for CEQA guideline 15183 consistency determinations, with tiering off of housing element and general plan EIRs becoming a more common approach.
Yeah, I think it can be used when there's some kind of tiering involved. And part of the well, we have the three basic categories of projects that are exempt, projects that are subject to an EIR, and projects that are subject to a negative declaration. There are some like new kind of CEQA categories, like the sustainable communities, environmental assessment, tiering you can think of as maybe like an EIR, but not quite an EIR. And if you're in one of those new and ambiguous categories, there's a timeline in the bill that a default timeline of 180 days for the city to finish its process. But I think if unless it's an exemption, it is the case that the applicant can't call the question until the document is actually presented at a public hearing at which it could be adopted.
And next question is about how this might interact with the builder's remedy provisions within the HAA. A number of cities have received applications under those provisions and have openly considered using CEQA delays as a method of obstruction. Are there ways in which AB 1633 could help those project applicants, and what would the timelines that would apply?
Yeah,
for something submitted before AB 1633 went into effect.
Yeah, so like 1633 doesn't address like how it applies to projects that were submitted before the law takes effect, which I think is January 1st. So I would be shocked if a court treated it as you know, the clock running prior to the law taking effect. So I think like realistically, probably a court would say the clock starts to run on January 1st if the clock, you know, would already have been running, or the court treats the clock as told until January 1st. If you think the project is eligible for an exemption, you have a very straightforward way to get the builder's remedy project processed, right? You just say, here's why the project is eligible for an exemption, and now city, you have 90 days to make up your mind, and if you don't make up your mind on the exemption, then you're in violation of the HAA. I can sue you. I can get a remedy of attorney's fees, and I can make a court take charge of the project. However, it's going to be harder for projects that aren't exempt, because again, the applicant can't call the question until the city has held a public hearing for those non-exempt projects at which the CEQA document could be adopted. And most CEQA exemptions require that the project be consistent with the general plan and zoning standards, whereas the whole thrust of the builder's remedy is that the project does not have to be consistent with general plan and zoning standards. So I think we're going to have to ask the courts or OPR perhaps to weigh in on the question of whether a general plan or zoning standard is applicable for purposes of say the class 32 infill exemption, if it's not one that a city can rely on to deny the project because of the builder's remedy. And that's really uncharted territory.
Great. So we have a couple of questions here, I think, about this January 1st application date, the date that the bill goes into effect. And what does this mean for project applicants that were submitted, before? Do they have, it sounds like what you're saying is they have access, probably if they think they're qualifying for an exemption, that they could try to call that question?
Yeah, I mean, again, the bill does not address this. So we're in uncharted territory. Nobody really knows. I don't think the courts would say, I'd be shocked if the court said the bill doesn't apply to projects that predated, whose application predated the passage of the bill. I just think the most likely outcome is the court would say the bill starts applying as of January 1. And so if the city has let's say 60 days to make up its mind on an exemption, or 180 days to make up its mind on an EIR, probably that time period would be told until the bill takes effect. So that time period would start from January 1. On the other hand, maybe a court would say, no, it's the city knew the bill was coming. They knew the requirements were coming into effect. And if the city has already had a year to get the EIR done and it hasn't gotten the EIR done, or it calendars the EIR for a public hearing at which it could be adopted on January 5, well, the bill's in effect. And so the city has to approve the EIR if it doesn't have a substantial reason to require further study. I just don't know.
Thanks, Chris. So next question from Ben Christopher asks about the standard for substantial evidence in the record that would allow a reasonable person to find qualifies for an exemption. Wonders wondering about this standard. It sounds, for those of us who are not lawyers, potentially subjective. So how consistent should we expect courts to be?
So that's the standard that courts already apply in cases where the city approves an exemption for a project and then an opponent of the project challenges the city's approval and says, actually, no, that project wasn't exempt. The city had to do an EIR. So it's not a new standard. It's a familiar standard for the courts. And it's one that historically has been very deferential to cities, because substantial evidence, I mean, the term sounds like it's something heavy, but in fact, given the precedent, substantial evidence is just like enough evidence for a court to conclude that the city wasn't completely off its rocker when it approved the exemption. It's not a high bar to meet. The thing that the bill does that is really significant is there's no longer a deference to the city on whether the project is eligible for an exemption or not, right? It's not the city's view, right, about whether there's substantial evidence in the record that backs up the city's decision made on whatever grounds to issue the exemption, right? Under the bill, if any reasonable person, i.e. any reasonable judge, could look at the record and say, oh yeah, if the city issued the exemption here, that would be an okay decision, then the city must issue the exemption. That's what makes the exemption mandatory. Whereas, like, as things stand today, if a city wants to issue the exemption, right, it has to document that there's substantial evidence justifying its decision. But if the city doesn't want to issue the exemption, the city can deny the exemption for any reason under the sun or with no evidence in the record. And the city is in the clear because there's no remedy under CEQA or the HAA for a city's failure to issue an exemption to a project that was eligible for it.
Great. And that seems to me to also speak to another question we got from Bridget McDonald about the unusual circumstances and cumulative impact exceptions to exemption eligibility. So I'm saying this is changing the weight of evidence that cities would have to provide to make that finding to deny an exemption.
Yeah, so Bridget's question is, couldn't a housing adverse city or a project opponent just find substantial evidence that a project is subject to the unusual circumstances exemption or cumulative impacts exception, which are just like saying, like, like as Aaron Peskin said about the Washington Street project, this project is near a playground. That's unusual, right? Unusual circumstance. Therefore, we're not going to approve the exemption. That might be Aaron Peskin's view. But under 1633, if a reasonable person could disagree with Aaron Peskin and say, actually, there's lots of sites in San Francisco that are next to playgrounds. There's nothing really unusual about that. The city has to issue the exemption. So it's not the like idiosyncratic view of a city official that counts. It's whether any reasonable person could say, oh yeah, I don't think this is a weird circumstance. And if a reasonable person could come to that conclusion, a non-crazy person could come to that conclusion, then the city has to issue the exemption.
Fantastic. We have a couple questions drilling in on the timelines here. So one from Brandon Young, can you clarify what the 60 days for an exemption is referring to? I thought the PSA has an unenforceable timeline for a determination within 30 days. And then another question from Michael Branson about cities extending the clock when the question is called from 90 to 180 days. My understanding on first reading was that it only could be extended for exemptions and not for negative declarations or EIRs, but you noted it's available in either situation.
Yeah. So where does the 60 days come from for the time period, the 60-day time period for an exemption? That's what the various groups that were negotiating over this bill decided was workable. So it's true that there's an existing opinion letter from HCD saying 30 days is the time for making an exemption determination, but this bill says it's 60 days. And it's 60 days from the time the applicant submits a completed project application. So advice for cities and applicants, for that matter, include in or require applicants to include in their project application everything that the city thinks they will need to make the exemption determination, at least if the applicant thinks the project is exempt. And then the other question was, sorry, what was the other question?
The ability to extend.
Oh yeah, the ability to
90
extend.
180 days.
So my recollection was that extension period was for both exempt projects and projects that are not exempt. But now that I'm thinking about it further, I'm realizing my recollection may be faulty, and I didn't look that up when I was making the slides. And so it's entirely possible that I have an error in the slides, and the extension of the clock to 180 days is only available for projects where the applicant calling the question says the project is exempt.
Double check the statute. And if you do end up wanting to update the slides, we can post an updated version.
Will do.
All right. We have some more questions here. I see we're losing a few people, but we still have quite a number. So there's a question with a tiered environmental document under CEQA guidelines 15183. There may be no hearing required for the project. So what does that mean for the applicant's ability to call the question?
That's a really, really good point. And it is not a circumstance that the bill expressly addresses. I would argue, if I were the applicant, that tiering, because it doesn't require a hearing, is in fact a kind of exemption. But I don't know how that argument will ultimately work out. I will say as well that this bill establishes a brand new legal framework for a problem that no one has tried to solve before. And as with most new undertakings, mistakes surely were made. Some problems surely weren't anticipated. And over the years, I think there will be a need to amend the bill to clear some things up. And that tiering circumstance is one thing that probably could be cleared up, probably should be cleared up. I'll add as well, the bill has a 7-year sunset provision. So the legislature is going to have to look at this again if it wants to keep it going before too long.
Yeah, and that's a great point about, most of these significant bills do require subsequent fine tuning. So for those of you who are, interacting with this law on the ground, whether as a project applicant or from a city staff position, we're really interested in hearing from you about what is working, what is not working, because that helps us inform that sort of follow-up legislation. I think Lewis responded to somebody's question about, an issue of, well, what if cities don't provide the notice that they're required to? This is a question. There's a question here as well about the Mahan notice, and if you include it, if an applicant includes it in their materials, is the city required to then publish that? But all of these issues, these sort of edge cases as they come up, in practice, we do want to hear about them, because it's always easier, I think, to get the legislature to address problems that they have an example that we can point to than theoretical ones. I think we saw that with this bill, right? The real examples from San Francisco were really important to motivating it to move forward.
And to Marty's question, the city has to give notice of whatever the applicant provides in their submission to the city. So I think it would be like a pretty transparent case of bad faith if the applicant provides the Mahan notice and the city failed to post it. And bad faith is a really bad thing for a city when we're talking about the Housing Accountability Act, because bad faith, if the court finds bad faith, it can order the project approved. If the city drags its feet, it can multiply fines by a factor of up to 5. So there are really good reasons for cities not to play games when they face a threat of HAA litigation, because the more gamesmanship goes on, the more likely it is a court will find bad faith. And this response also, I think, speaks to anonymous attendees' question. How long would it take to adjudicate a case, for example, in San Francisco? Seems like the bottleneck would just shift from the Board of Supervisors to the courts. And I think the answer to that question is, this bill, if it works, is not going to work because all of a sudden it's courts that are resolving questions of CEQA compliance in the mine run of cases. The bill is going to work because cities don't want to be paying the attorney's fees of project applicants, and cities don't want to be risking court-ordered project approvals. And those special HAA remedies for bad faith by cities will, I think, coupled with the provisions of the bill that discourage NIMBY litigation, will, I think, encourage most cities to play by the book in most cases and issue those CEQA exemptions to projects that are, in fact, eligible.
Thanks, Chris. I see we've got some more people dropping off, but I know also you've been going through the questions. Are there any other questions in there that you particularly want to answer? Or any other last comments you'd like to leave us with?
Is there a good source to find more information on Mahan notice? I included, this is Diana's question, I included a link in the slides to a primer on the Permit Streamlining Act. I will say as well that, excuse me, there's some open questions about whether the Mahan notice is even required, and some further open questions about whether it might be a violation of some strange 1970s era California due process case for a court to recognize an automatically approved permit in cases where the city has substantial discretion to do something with the project. I don't see that due process thing as turning into a problem for HAA protected projects for reasons I'm happy to discuss at length if and when a case presenting the question is actually litigated, or there's a threat of litigating it. But there will be a need now for cities and developers to come to some understandings about how to provide the Mahan notice and what goes into it.
Wonderful. Well, thank you so much to everybody who joined us. Thank you again to our co-sponsors on the event and for AB 1633, Hack, Back, and Spur. Thank you again to Chris for this really informative presentation and for answering so many questions. And we will follow up with all you as attendees with Chris's slides, and we'll be posting the recording for this event on California YIMBY's website. So you'll be able to refer to it, and you'll also be able to share it with any of your colleagues who maybe were interested but unable to attend. We will make this recording available.
Thanks so much. I really appreciate all of you coming out, and I'm happy to take further questions as they come up. I can be emailed at the UC Davis account that you can find online, or reached through Twitter if you want to be flagrantly public about it. So it's interesting times ahead, and like Aaron, I'll be really keen to hear war stories about how this 1633 process is or isn't working out on the ground. Thanks again.
Thanks, everyone. Take care.